on 8-2 order, Lordship.
8-2. Item number 18.
18 and 19 together.
18 and 19. We both were there.
Four 2017 criminal appeal, Lordship, on 8-2 order. 8 February 2024.
Mr. P. Chaudhary. Learned counsel for the appellant. MS has it. Additional public prosecutor for the sake of some and Mr. L.R. Muthu.
LR.
Learned counsel for the info. Have submitted that the appeals have been heard in part by under judgment. Read back to PG. Here, Purana J. and it will take on 8/12/2024. The learned counsel for the parties have submitted that. I think that bench may be available. Where is the case standing? Office to verify. Starting verify the thing and release the case. The bills accordingly.
Highly obliged.
I did to mention for listing a criminal jail appeal, Lordship. For 2nd of April, Lordship.
Jail appeal for what?
Lordship, against conviction, Lordship.
Admission.
Hearing, Lordship. Hearing.
You pursue for the HP.
For admission item number 1. That is a POCSO case, Lord. The accused is convicted. Under section.
Notice was issued to respondent number 2, Lordship.
LCR not received.
LCR is awaited. Receipt of LCR as well as service report is awaited.
And I will be considered on receipt of LCR and
File,
service
file.
report. Main appeal of TTP.
I have not gone through the office note matter. Some office note.
Third, Mr. DCC Pukon, learned counsel for the appellant, and MS S.H. Vora, learned additional counsel for the responsibility. Office note dated 13/3/2024. Office notes. Dated 13/3/2024. Indicate that the trial court records and service report in respect of the number 280 are not received. Same, I please the MS Vora when it is expected.
Lordship, 1 week or 2 week time may be.
2 weeks.
Well, the date may kindly be fixed. 3rd of April.
Only is the
Apply, sir.
bill
Well,
on 3rd of April. And similarly, I
obliged.
yes, good.
May I please, your lordship?
Hmm.
My lord, the appellate convicted for life, my lord. Page 82, my lord, the order.
How many appellants?
My lord, here are five
Five.
appellant.
Heard Mr. N. Uddin, learned counsel for the accused appellant and MS S. H. Bora, learned additional public prosecutor for the respond number 1, date of the criminal appeal is direct. Criminal appeal under section 374 in bracket Code of Criminal Procedure is directed against a judgment and order dated 30/01/2020 passed by the Court of Learned Additional Session Judge Tilapipara, Command District Dhubri, in sessions case number 66/2016 by the late judgment and order dated 30/01/2020. How many were convicted?
My lord, total 9.
9. Out of that, you 5.
Yes.
Okay. The accused appellants have been convicted for the offenses under section 147, is it? 140, section 148, section 323, section 324, section 326, and section 302 of the Indian Penal Code. All the accused. And each of them have been sentenced to undergo simple imprisonment for 3 months under section 147, full stop. All the accused appellants have also been sentenced to undergo simple imprisonment for 4 months under section 148 and to undergo simple imprisonment for 1 month under section 323 stroke 149 IPC. For the offense under section 324 stroke 149 IPC, the accused appellants have been sentenced to undergo rigorous imprisonment for 6 years. And for the offense under section 326 stroke 149 IPC, they have been sentenced to undergo rigorous imprisonment for 6 years and to pay a fine of rupees 5,000, in default of payment of fine, pay fine, to undergo simple imprisonment for another 1 month. For the offense of murder, under section 302. To read with section 149, IP. All the accused appellants have been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000 each in default of payment of fine, to undergo further simple imprisonment for another 2 months each. So all the sentences are ordered to run concurrently. The appeal is admitted for hearing. The trial court records 344. Issue notice returnable on TT 4 weeks. As MS product appeared and entered appearance on behalf of respondent number 1 is already performed. Hence, defense of formal. About steps to respond number 2.
Yes,
Yeah.
Lordship. It's not required
It can be by registered post.
raise the
The appellant will take steps for service of case upon the respondent number 2. Informant by registered post AD within 3 working days. Any other step?
No, Lord.
Is the case concerned.
Wait, please, your lordship. Also, this appeal was otherwise fixed for hearing, but following the judgment in Deepak Naik's case, my lord, the notice had not been issued to the respondent number 2. So on the last date, notice was issued. Now, office note shows that service is awaited.
Yes,
We'll take instruction to
Huh?
that regard.
how much time?
10 days time maybe.
Yes, Nawaz learning council for that. And MS Bora. SS Bora and technical copy. One. In view of the office notice dated 13/5/2024. Release the case till after 2 weeks appeal date. Many for service report in respect of respondent number
2.
2.
Lordship.
Deeply obliged, my lord.
Application for 389. Notice has been served upon the respondent number 2, so the application has come up for hearing. 389 application.
My objection is on record. I filed. When my learned friend has filed it.
I do some.
Well, for your lordship's convenience, I'll just make a compilation of the deposition and the medical report, just handing it.
Because since I'm a legally consider, I don't have all the entire record of deposition. So if a paper book is ready at this
I can provide a
then-
copy.
then it will be-
Paper book is not ready, perhaps.
records are here. Thereafter, if it's taken up for hearing,
My lord, I'm providing her the copy of deposition. I have made a copy, extra copy. That's a very small issue, very small issue. Apparently,
go through all the depositions.
without the depositions, even without the depositions, I'll argue just one point. She has been, the
Lordship, there is the office,
FTP or no service report.
no service report was awaited, Lordship. And we have already sent a written intimation to the concerned PS, Lordship. But no report has been received yet.
Amit, then after two weeks, you are amicus here.
Amicus.
Okay. And
So, yeah,
other thing is your lordship can see that he is in custody for 4 years, 8 months, 9 days.
let service report be
On the date may be fixed.
fixing date before Bihu will be difficult then.
After Bihu or
Yeah, made learn it because MS S8 Bora learn it additional copy. But number one, in view of the office dated 13/5/2024, comma, list the appeal on for service report in respect of the respondent.
public.
Alright.
Same.
Lordship, yes, I think I have not filed my objection. I'll file it within a week or so.
Is there any
Proper
I also?
There's an I
Okay.
Five,
That
please.
service is not complete.
not complete. It was sent to us. I must have sent it.
Okay.
Our office must have sent it.
In order, we held you are appellant.
Yes,
For
Lord.
concept appellant. As Jahan additional copy. But respondent number one state of Assam in view of the about 13,024. Many people. I MS Beholder concept as Jahan additional copy. But opposite party number one state of Assam. MS Jahan has sought for 2 weeks time.
Not 2 weeks. Enough.
2 weeks time. File objected the interlocutory. Full stop. In view of the office not dated 31/2024, comma, David.
I
Yes, after Bihu,
after
let review. Go ahead. Yes, some
Lordship, it is
issue has arisen.
AB to LCR along with service.
Office note says notice could not be prepared and handed over to the IPP.
Lord,
Since specific name, address of the informant could not be traced out from the impugned judgment of the trial court.
Lord,
Notice will be prepared and handed over to the APP after receipt of the lower court record.
Lord. So it will take time perhaps.
Huh?
It will take time for
So you can issue a reminder.
reminder.
Where is amicus? MS, that's it. Bora. In the appeal, no address is furnished.
Lordship, paper book is not with
What is real appeal? Perused the office note. Dated 13/5/2020. Office to send reminder for the trial court record. For case records of special, you can get B, case number 19 of 2000. From the court of Planet Special Judge, House Salmara. Release the case on
Lordship.
It is a lordship, same kind of office note dated
Same kind.
33/20, same.
R.D. Mojumdar, Mikas. Say, Bora. Same office date. Not dated.
Sound.
Same order, same date.
Maybe the case number will be.
Yes. POCSO case number 67, 2018. Additional station judge, come special judge, Military Bracket POCSO.
Highly obliged.
May it please the Lordship, my senior M. Datta, he is appointed amicus in this matter. We have not received the paper before.
Babu is not prepared.
Not prepared, Elser has not been perhaps.
Same thing.
Yes.
Since it is ambiguous should not be replaced by anybody. I'll not record M. Dotto. Additional public. Case number special putting bracket POCSO case number 52. Court hall special judge putting bracket POCSO document not it.
Not.
May I please? I have been appointed as amicus.
Huh?
I have been appointed as amicus Q.
Campaign. Jada.
Jayaraj.
LCA received.
Elser
Elser
not
received.
received, Lordship. Awaited receipt of Elser as well as council.
LCA
Elser
received.
To prepare
Sorry.
paperwork then.
His paperwork.
Mr. Jadas. Right. Amicus. NMS. Passage one. Turn it. Editing. But I responded. Bit of stuff. As trial court record. Are received. Comma. The office to prepare paper book in an expeditious manner. I'll raise the case at the end of April.
Okay.
That is not. LCR has been received. Paperwork.
Okay. Received. That's the Purogast and Vidas and learn it. As the trial court record prepare the paper. Actually, leave the case on side.
Obliged.
Lordship, service is
Need
not
to-
complete.
You can service report received.
No, Lord.
It has gone only on 11th of March. Okay.
Mr. A. Hussain,
Lord.
learned counsel for the applicant and MS and of an additional public prosecutor for the respondent number 1. In view of the office note dated 11/3/2000, as per office note dated 11/3/2024, notice has been issued to the respondent number 2 to registered post as well as by usual process on 11/3/2024. So, please the case. May 1st, 3rd May, for service report. Respondent number 2.
So this is another 389 application. Without going on the merits, my lord, the applicant is suffering from schizophrenia. Your lordship takes the IA, page number 28.
Offense is what? Seizure?
Schizophrenia.
No, the offense is what?
Murder. 302.
Seizure. Yes. Which page?
28, my lord. Last page. My lord, this item number 6 here, Puniram Nath. Lordship can make out. In the IA, my lord. Not
Yes.
page 28, the IA, last page of the IA.
There is prescription.
Prescription. My lord, this name is Puniram
Handwritten
Nath.
prescription.
Yeah, handwritten prescription. Now, it is by the superintendent of the Morigaon jail. It is endorsed down below. My lord, this,
Who is giving this?
my lord, in the jail doctor.
Jail doctor.
Jail doctor. My lord, this tab, olazipine or something like that, which is given to him, that is generally given for people with having schizophrenia.
Is there anything there in black and white schizophrenia?
My lord, that is what I'm suggesting. If a report can be called from the jail, that what is his condition? Because the mentioning of the tablet, this is the literature I have found out. It is given for schizophrenic persons.
Jail doctor whether can prescribe medicine for
Yes.
schizophrenia.
My lord-
That is another one.
My lord, right?
But will
Yes, my lord.
Lordship, I will
No,
bring
no. Yes, a report can be
medical
called.
report. You are seeking suspension of
Suspension.
sentence on that ground.
On that ground. And in fact, he can't even be let out of
But
jail. He has to be
Mr.
seated somebody else.
DK for the site. Counsel for the applicant and MS and learned. In appeal, anybody has entered appearance for respondent number 2.
No, madam. Respondent number 2 is his relative.
Relative is informant.
Relative. He killed his own uncle.
So maybe he may have some animosity with you.
My notice has gone, I guess. Notice has gone, but nobody has.
What is the status?
My lord, in fact, there has been a order that we had to file the tracking receipt by affidavit. That office note
Sure.
states that.
1 minute.
We have filed an affidavit.
Lordship will
And there's
definitely
NFS
file an
and the
objection.
learned additional public prosecutor for the opposite party number 1. State of Assam. There is an application under section 89 CRPC by the applicant seeking suspension of the execution of the sentence he is presently undergoing. The applicant, as the appellant has referred the connected appeal, criminal appeal number 16/2024 against the judgment and order dated 20/09/2017 passed by the learned station judge Morigaon case from 2016, whereby the appellant has been convicted for the offense under section 2 IPC and he has been sentenced to undergo life imprisonment with and to pay fine.
Fine of 5,000.
To pay a fine of 50,000, come out with default stipulation. One of the grounds are in the instant application is that The applicant is a patient of schizophrenia and has been undergoing treatment for the same for a considerable length of time. It is stated that the treating doctor has prescribed medicine to the applicant, which are meant for schizophrenia and meant for schizophrenia. MS Das learned medical subject that a report, the medical report in respect of the applicant to the jail superintendent would be necessary for the purpose of consideration of the prayer made by the applicant in the instant application.
LC.
Will give a TK for the for the and thus the application of officials indicate that the trial court records are not received. As per official dated 22/02/2020 service report, neither service nor ID card has been received in respect of an notice sent to the respondent number 2 an affidavit has been filed on behalf of the applicant to bring on record the a copy of the postal service report indicating delivery of the notice upon the respondent number 2 para. The matter be placed before the Lodging Court
My lord,
to assert it.
notice has been received. The affidavit that we filed.
You have filed.
Yeah, no, that it says received, delivered. Okay, my lord.
You have filed. I have recorded.
My
Normally, what I do, I place it before the Lodging Court, get it verified,
my
give the report,
my
then notice is deemed to be.
my lord.
Placed before the Lodging Court to assert it and verify the delivery of notice upon the respondent number 2 and to submit a report to that effect. All that report, medical report.
For this week,
It's
2 weeks.
2 weeks. It's
Public.
Yes.
Please, my lord. This is a appeal against the conviction, my lord.
What offense?
6, my lord.
What is all respondents?
Respondents and my lord, they are
This
acquitted.
is
my-
appeal against acquittal.
Acquitted, my lord.
Appeal against acquittal.
Yes, my.
Yes. Appeal against acquittal.
I think notice should go to the respondents.
There are many.
Yes,
Notice should go. This was by register proceeding.
yes.
For Mr. A. M. Ahmed, learned counsel for the applicant. They are acquitted of the charge and the
302, my.
302.
NMS SH for an additional public prosecutor for the opposite party number 1, state of Assam. Also. How many days?
36, my lord.
The present application is under section 5 of the Impeachment Act is preferred seeking continuation of delay of 36 days, which is stated to have occurred in preparing the connected appeal, which is yet been offered. The applicant has submitted that the connected appeal has been preferred against the judgment and order dated 8/6/2023 passed by the Court of London Additional Special Judge, comma, additional special judge.
No, sir.
Ah.
Special justice.
It's additional sessions as Dhupri, my lord.
I have not found any additional session judge yet. You have
Here,
given
special
the
judge, doctor.
designation to him.
no, no.
Huh?
302.
Before giving, the state of Assam, government of Assam is giving any designation as additional special judge. You have given them. Additional session judge.
Yeah.
Copy paste. Copy paste.
Sorry.
Dhubri, Assam, in sessions case number 286, 2015. Where charges were framed under sections 147, 148, 150B, 302, 201, 34, IPC against the opposite party number 226. As by the judgment and order dated 8/6/2020, all the opposite parties were acquitted of the charges pending against them. The applicant has preferred the connected appeal against the judgment and order of acquittal. Issue notice returnable on 4 weeks.
4 weeks.
SMS for public has appeared and accepted on behalf of the opposite party number 1, state of Assam. Issuance of property copy. The applicant shall take place for service of notice upon the point number 2, opposite party number 226 by third pursuit AD as well as by usual process within 3 hours.
Yesterday,
Yes.
21 to আগতে
Ah,
বসে
Time because will be this
The bench will be broken up after.
Yes.
This bench will be broken up after today. Yesterday,
Yes, your lordship has.
traffic. Whether if time permit, will do it.
Before we proceed, my lordship, I have always stated yesterday that
Huh?
already there are two accused persons in this case, my lord. Who were convicted in the case, and one has been already acquitted by this honorable court by judgment and order dated. I have also given a copy of that
Judgment order. Okay, what is
dated
the connected-
22/4/2000. This that
Huh?
accused person got a separate appeal, private appeal here. So so that in and
Right.
it is there, I think,
There is not.
So
Actually,
actually that benefit.
it is here. Let me have a copy.
So there are judgments and the benefits should also.
Let me have a copy.
Oh, that judgments.
In this file, it is available. In this file, it is not available.
No, I have got copy also.
We'll get it. No, what is the other? What is the principle otherwise?
Otherwise, case is my lord, the judgment is just page 55.
No, what is the principle otherwise? There is one.
Yes, principal manner that the non-appealing accused person also to get the same benefit if the
Where it is later.
the judgment got it.
After that first.
Sorry.
First, let us go through this judgment and we will have intent. Yes, which judgment you are saying?
I'm
One,
giving,
one is acquitted, the other is
one is Suresh, and one
This
is
is
Raju.
benefit to non-appealing accused. This appeal was of 2018. Similarly, jail appeal was also 2018. Why it was not taken up together?
Because that is a private appeal matter, and this one is as I am as an amicus curiae. I am.
Otherwise also, from the jail judgment, it should have been taken up together. It was not taken.
Later on, I maybe.
See the charge.
Page 6.
It was with 34.
Yes.
How many? Because
14 witnesses.
14 witnesses.
Two are declared hostile, my lord.
because something to be that paragraph 6 in the coordinate bench
Yes, ma'am.
paragraph 6. And it was based on the statement of PW4 under section 161.
He
CFS
was-
is also inconsistent her deposition before the court. Right now, what we have been holding last week, it should go contrary to it
Because
because it was not marked and put to PW4
Yes.
and it was put to IO. It was not like that. So it would be difficult to observe so directly. Directly. In the sense, have you got the
Lordship.
in toto? It will be difficult to agree.
My lord. Even otherwise, my lord, the occurrence had taken place within the four corners. This is an exception to the circumstantial evidence because the occurrence had taken place inside the four corners of the house. And incidentally, all the witnesses have deposed. She was sitting beside the victim. She did not make any hue and cry, lordship, and she owed an explanation, my lord, to give. If her presence is proved that she was in her residence.
Just let us have a
she
look at
immediately
it.
informed to her.
No, we have not gone into. Let us have a look at PW4.
And even without her explanation also, prosecutor has to stand on our own feet, ma'am, because
That is what we are looking.
and this
Let
car
us
we-
see, just have a look at PW4. Because we did not see the
and there is nothing
Korean
in
bank
evidence
judgment.
that there was some mainly the
because some observations are made here contradiction with the statement of section 161 CRPC without the proper procedure perhaps. I cannot directly
Go into the hospital.
totally agree with it because what I've been observing in last
My lord, 2-3 days.
2 weeks, it is somewhat not consistent.
My lord.
My observation will be inconsistent.
My lord.
Then that is why I'm just let us have a look at
My lord.
PW4 first. Let us have an independent view first.
Sure, ma'am. That is the
So
optical having-
there's a judgment to that effect. 91-1 ani se nahi dada. 5-1.
PW4 at page 50.
All your suggestions,
Lordship,
all your suggestions in a cross. Nothing was directly, previous statement was not.
we don't do, my lord. The lordship is fine. Maximum cases procedure don't follow. They don't follow the procedure. The IO, the APPs.
Why she has been roped in? Why she has been roped in?
Because she was present. Initially,
Present.
she was a witness actually in the case. Later on, when justice was submitted, then she has been
Lordship,
roped in as an accused.
I thought
Daughter-
that but you were similarly situated. I never thought that he was the wife,
Yeah.
the same room. And
So the story would be different, my. When they are the inmates of the same house,
But
I
the
thought that I thought that 34 means three of you
my lord.
have gone there. Everybody
No.
participated in the same
Lordship,
manner.
I have not gone through 161 whether she has stated as she has stated before in the substantive evidence. This witness PW4, she has it is similar or different.
That I have not seen.
only
I have
because
just
she was
seen the,
present, man.
the deposition in Assam. The deposition of PW4 in Assam.
But nothing comes out from PW4 or even 7, her 7 also,
Hmm.
regarding her
No,
involvement.
no, I am not about. I thought that it is simply 34. Everybody attacked somebody.
No, no.
It is not that. Your position is somewhat different.
Different. So I'm submitting that.
This judgment be difficult to
Rely on.
not say that. Difficult to refer to say paragraph 6, right? And paragraph 8 and 9. Because it was based on inconsistency of the PW4. With regard to 161 CRPC.
So that is with regard to the involvement of the
No, no, yeah, you are-
Muslim bylaw,
you are
not her.
Actually getting the point.
Yes, ma'am. That is the regarding that one month, that other accused person.
Right.
Yes, not this case.
No, extensively quoted PW 14 statement before the court, testimony, that the PW4 also did not state in her previous statement. And judgment is based on that.
Lordship,
There is inconsistency in the evidence of PW4 with regard to her
totally.
previous statement. And judgment is delivered on that aspect. Now, for me, after holding yesterday, day after yesterday, this is not the procedure,
My lord.
correct procedure
Ma-
to rely on 161.
Yes, my lord. Lordship, I'll be relying
not-
91 one SCC.
Even then, my lord, PW,
But that has to be independently
My lord.
assessed.
other,
Yes.
ma'am, there
That,
are rely.
that has to be independently assessed.
PW 1 and 3 also did not state that the PW 4 has stated before.
She is the
Yeah,
wife,
so
she was
she-
very much
no,
present.
Present, but she didn't
The
comment.
occurrence have taken place 4 corners. All these factors will go against her. She
But-
did not give any explanation in 313.
In that presumption will not apply here in this case, my lord, because this is not case where presumption will operate, my lord, because he was present there.
Otherwise, how many?
14, my lord.
Just two have been declared hostile, and then two are still, and others are mostly relatives of the.
If you have a good case for acquittal, one will be having limited. That is what. I thought that it is 34 will. 34 in the sense that everybody has the same rule.
Yes, that
But
I was of the impression that everybody has the same role, same participation. But you have been, I think, roped in because somebody suspected
suspect conspiracy parties.
some affair with the
mortally acquitted.
appellant
Acquitted.
who has
Acquitted.
already been acquitted.
Man,
Perhaps.
assailant, man, who is
Uh,
actually who has been targeted as an assailant.
So
man.
in 91 one SCC, it has been, even if one accused is acquitted, the lordship may independently look
Right.
into the
Right,
evidence.
right. That,
always-
that,
that is always
becomes
there.
the difficulty.
Yes.
That becomes the
Why not?
difficulty
Why
now.
That is yeah, but when the allegation is the main accused person, main allegation is against the person
Mr.
who is the assailant, man, he has been acquitted, my
No,
lord.
I am
on this-
understanding it.
And discarded, evidence has been discarded, my lord.
Will not be able to. That is the difficulty.
Well,
Mr. Hazarika, I think you might have a very good case, perhaps, but will not be able to complete it. I thought it is simply same participation. Everybody participated. Already your co-accused has been acquitted.
so
But the
apparently-
basis on which this judgment is, in fact, it will be difficult on my part. I have to make independent, we have to make independent application of it. And which requires scanning of evidence of 14 witnesses, which is difficult. Because otherwise, it looks like you have a prima facie good case.
Nothing is there in this. So very-
No, difficulty is not that,
Hmm.
Mr. Hazarika.
bench ka na kaya.
Finishing
No,
there, where I'll be elsewhere,
Yes, well, that
my sister will be elsewhere. That is a difficulty. Had it been a short judgment like this, I would have ABC gone there, attacked together. One has been acquitted, the other has been others appeal is still pending. I thought that is the way. Oh, I think so. Out of no. There is one. I have to pass order. When you want MS Bhuiyan,
Any day, lordship, in after a week. Fully went.
you have a good case, perhaps,
good case for
for appeal.
I'll try to make out a case.
but he may make it difficult.
You might have a good case. And additionally, because your co-accused, co-convicted person has already been acquitted. That is one additional factor. It needs expeditious disposal because it is jail appeal. It is jail appeal.
Lordship,
It needs expeditious disposal next week.
after
Even
the week after Holi,
Exactly.
or last week, this month,
एक तारीख को
La-
जो पड़े अप्रैल और एक
April 1,
last week of this month, if that's possible.
last week 29 is
29 is a holiday.
holiday.
29 is a
Only 2 days, 2 working days. Last.
एक एक तारीख था एक बार भी
on one. दुईटे को जाती है वहाँ तक नहीं on second of April in
MSB, your submission would be, I think that this is to be independently assessed.
Lordship.
The case of this appellant is
My
to
lord.
be independently
My lord.
assessed. Alright, I have. And in case. For the evening. Submitted by the learning author for the party that uh, the two accused were convicted by the same judgment in order dated 27/10/2007 for the offense under section 302 IPC read with 34 from IPC. Full stop. Mr. Hazarika has submitted that by a judgment in order dated 22/4/2019 passed in criminal appeal number 37/2018, preferred by the other co-accused and convicted, he had already been acquitted. The other accused person has already been acquitted, and the appellant hearing is still in jail. Jail.
In jail.
No bail. Bail is not done.
No.
Considering that release the case, release the appeal on 2nd of April, 2nd of April for hearing. Because I would have to again rise
Lordship.
early.
Single bench is also.
Again, single bench, then thereafter I have to rise.
Again,
2:45. Mr. Ahmed, today in difficulty. Some other studio date. This is 23. That is 2018.
Probably
After
here,
Bihu.
probably here, Lordship, this matter will be remanded back or something like that. So we have prayed next week any date.
No, next week I don't know how many cases are picked.
For your Lordship, my password for that day, I will talk with the registry.
We'll just pass over for that one. And stop for by the land. Ahmed land for the appellant. Like it pass over for that one. It's leave me and
How long?
My learned friend was directed to obtain the instructions for the withholding the
what are the other repetition? Number?
WPC 822/24.
That is my case. That is my case. I thought earned leave. Thought for earned leave that has repeated. That is my case. It's not that I have not projected something. I've tried to mislead this court by not concealing certain facts. But I applied for casual leave, not granted, just like my husband. Then I requested to convert it to a earned leave from that day onward to a particular date in the month of March. That also rejected. Medical board constituted their report. I have not been informed, even though I appeared. Repeated request for review of my application rejected. He calls up the officer in charge of the local police station, sends them to my house to check whether my husband has done domestic violence over me. I reply that nothing of that sort has happened. Immediately I write letters to the register vigilance of this court. All this been happening, and the only ground which I have taken is malafide against the private. That is the only ground of felony. Nothing else. Even today I can cite instances that every day what he is doing. Yesterday also I got a call regarding some things being done to the husband, which I will place in that particular connected matter. And salary, without there being any suspension, any charges.
Not that maybe you are alleging malafide, but whatever document, application, whatever was not accepted, then you try to get early. Rightly or wrongly, the disciplinary authority or appointing authority has the authority. Decide on it, allow or reject. Therefore, you have fought early. But prior to that also, there are many instances
There were
that you,
few days which I was absent. Yes, another
not
so-called
only few days, quite many, if the record is correct. It is not that
yes, there were two so-called. One for earlier
it is
instances.
not that one-sided thing.
But again, my lord, the salary part.
Salary is,
How can it be withheld from
referred to
5th of January?
medical board has found it to good enough. There is no such medical complication on your part. Everybody has high blood pressure, diabetes mellitus. And it is not that only the medical board consists of the director, joint director of the two associate professors of a medical college. Check everything.
So provided my learned friend brings all of this on record by reply, I will give my reply to that particular affidavit also.
Because they have referred
But
to
again,
the
my lord,
office memorandum also, that whenever there is no unauthorized absence, then there could be stoppage of pay. What is failure? What is a failure?
The show cause, for setting aside the show cause, to
Which is
release
the so-called
that's 49.
age
49.
49. What is the case of your husband?
My lord,
He left suddenly on 5th of January for Guwahati.
Yes.
I think, if I remember
joined on
correctly,
8th.
sending an application for casual.
Casual.
And the authority acted on it.
Yes.
We found privacy that there is one
And
emergency can
charges were
happen
dropped.
to everybody.
Yes. Yes.
Even emergency can, it comes unexpected. It arises suddenly. Your son's complication was there.
Yes.
So he said he had to leave suddenly for Guwahati. And
He was suspended
eh,
and then charges were dropped.
huh?
He was suspended and
But
then charges.
At least we said that no final, because we'll
Yes.
examine that.
Yes.
Because there is no such procedure that, but otherwise, your husband has given the application seeking casual leave in time almost on the day
Same.
on which he sought.
Yes.
Privacy finding some court, we have said that maybe it may go on, but no final order. We'll examine this aspect. Now, did you reply to this super?
I gave my reply. Page 50. Next page.
Whether any memorandum of charge has been served?
No.
Till
No.
date?
No.
And what is this judgment?
I'm sorry, my lord.
What is this judgment at case 55?
My lord, this is to establish the Melafite, my lord. How to establish the conspiracy with certain staff of that establishment.
This against whom now you are alleging Melafide? Was that authority in the helm of affairs then?
No. No.
This is a new thing.
This is a new.
This authority, this disciplinary authority,
Yes, he joined recently.
she joined later on.
Yes. Perhaps in the month of November last.
So this writ petition may not be
My lord, I have tried to-
directly, anything from here cannot be directly attributed to this disciplinary authority. Maybe you have some
Yes.
relations, say, something to say against your colleagues, maybe.
Yes. Yes.
And earlier disciplinary authority.
Yes.
Because this is of 2020.
Yes.
Normally, a judicial officer is transferred after 3 years. So, from there, we can infer that this authority might have joined later.
And in the show cause, it is also absent that why that my salary has been withheld. In the communication, giving my salary statement is just a forwarding. No information of why my salary has been withheld. Until then,
Since
no
you have
memorandum of-
replied, if the reply is found satisfactory, it will be dropped.
That is
Otherwise,
correct, my lord.
memorandum of charges will be brought.
That is
We will
correct.
decide about that. I mean, we can issue notice. At this stage, we cannot stop the show cause notice. Normally, show cause notice is to be replied.
Yes, it can be dropped. But it,
That- Your prayer will be considered on a returnable date. Let them decide in the meantime. There is no bar. Not joining, yes, no. It is, this is also that it also reflects. It also perhaps reflects some indiscipline on the part of the petitioner. It is not that you were on leave for 1.5 years earlier. You joined office on 13/12/2023. 1.5 years earlier, you took CCL and all maternity leave, got it, extended it, and up to 1.5 years. Just joined on 13/12/2023. Then thereafter, again, from time to time, if one goes on seeking leave, again you are seeking early for months. Already you had availed 1.5 years. till December 2023. Then you were, what is the so-called? You attended for 4 days, then again you started taking leave. It is not that the picture is bad from the side of the disciplinary authority. Picture emerging is also not that good from the side of the petitioner also.
Let's run it inside.
This is also not the way. Some disciplinary issue is also there. You may allege malafide, but things are not that good from your side also. After availing 1.5 years of leave till December 2020, you join. In fact, that casually. Prima facie, if your child was was having some medical health issues on 5th of January, we thought that it would be proper.
And Lordship has granted that much protection.
It's not we thought, but this instruction appears to be not that, because you have been examined also by a medical board. I also saw who are the members. Members are two associate professors of Dhubri Medical College and Hospital, then orthopedics, then civil hospital, senior medical and health officer, civil hospital. Everybody says, then ophthalmologist checked you, orthopedician checked you. Everything was checked. Only high blood pressure and diabetes mellitus, which can be, one has to continue with medication. That is all. Medication and lifestyle change. That is the advice everybody gives. That is bit difficult. And there is an office memorandum of the government of Assam also, which they are referring to. An officer who is absent from duty without any authority shall not be entitled to any pay and allowances during the period of such absence. Since your early application is denied, some disciplinary issue is there. Maybe a case of insubordination also at the same time. Something is there. And this administration has to run. And board has to see also. Allegation, counter allegations is all right. But in the meantime, in the process, if the administration suffers, one may not be entitled for a relief before a writ court. That is of paramount importance. Just because employer and employee have some issues, administration cannot suffer. That is not permissible. You consult with your client. I think if the better sense prevails, maybe there could be a high-handed action, but what? See, firstly, I can apprise you on maternity leave and CCL. Petitioner was on maternity leave and CCL without joining from 21/6/2020, from 21/6/2020 to 12/12/2020 for a continuous period of 1.5 years. And joined office on 13/12/2023. Thereafter, she proceeded on CL again from 14/12/2023 to 19/12/2023. Okay. Again on CL from 22/12/2023 to 30/12/2023. And pursuant to joining office after CCL, the petitioner attended office only for 3 days in the month of December and only 3 days in the month of January 2020. And alleging against somebody is okay, but throwing a stone to a glass house when you are also in a glass house, it is a bit difficult. Otherwise, we are alive to suffering of an employee, but in the process, the employer also suffers, and we have to see how the administration is to be run. And ultimately, it is the administration of justice which is suffering. I'm making it clear. If the wise counsel prevails, it is okay. We only issuing notice. We are not very happy with the conduct. Extending leave and leave. Okay, child, okay, we can understand. But your health condition is not that bad to attend off. Well, you should simply notice the board was. And considering that medical board consisting of competent doctors examined you, found nothing except high blood pressure, which everybody has, diabetes mellitus, which everybody has, almost 20%, 25% of the people. And they have said with medication and lifestyle change. That's all. Third, Mr. will not comment anything at this stage. Learn it. Three borders, learn it. And Mr. H. Kerat, learn it. Standing counsel. Guwahati High Court for the judgment number 120. Will not be issuing notice prior to judgment number 4 at this stage. Having issue notice returnable on 19 June 2024. Issue notice. After hearing learned for the parties, this court is of the considered view that, at this stage, notice is not said to be issued to the judgment number 4. So, the issue notice to the judgment number 1, 2, and 3. The notice is made returnable on 19th April 2000. As Mr. Das, learned many he has appeared and accepted notice on behalf of judgment number 1, 2. Issuance of formal notice is dispensed with. Mr. Bordo, learned comfort of shall have furnished requisite number of extra copies of ready along with an access to them. Thus, we need 2 working days. As Mr. Das has submitted that he has received preliminary instructions, he would file a preliminary affidavit of opposition. An affidavit of opposition on or before the returnable date. So, the prayer for interim relief is kept open for consideration on the returnable date. In the meantime, if let her consider the reply to the so-called, because the issuance of memorandum of charges should precede an application of mine whether reply is satisfactory or not. And that so-called, you have to take only the events depicted in the so-called, not the subsequent events. For the subsequent events, you can issue press so-called, it is a different thing. So, please consider me so-called and reply to that. Take a call, find that memorandum of charges is required to be issued, okay, or otherwise drop. And so far the subsequent events are concerned, take a fresh view, but do not get influenced by the subsequent. Right. Please convey that. Subsequent events may give rise to a cause of action, but that cannot influence the so-called notice and the reply.
Apply.
Oh, or you require. Okay. The instructions placed by Mr. Das, as Standing Council, DHT, are to be kept with the case record. Mr. Bhardas, you can have a look. You can have a look.
May I please. Now, on last occasion, my lord, this honorable court has directed respondent 7 to take steps for listing.
We are not
the
directing
petition.
the submission, so we kept it open. Because that will be, because I don't know, to my, in my estimation, there is some mistake in putting the read petition number. Otherwise, the earlier judgment, right or wrong, it has not been set aside. And in the meantime, there was a press read meeting. I think what was meant by the division bench was that all issues would be open in the subsequent read meeting. But this number 1441 ought to have been some different number, the other one.
7584.
Heard Mr. DJ Min, and counsel for the petitioner, Mr. D. Bordodoy, and standing up for NMS A. Talukar, and counsel for the private response. MS Talukar has counsel appearing for the private response submitted that the defects in the application with filing serial number 5841 stroke 2023 filed in WA number 55 2022 have since been rectified, and the interlocutory application has been numbered. Calcutta has the sought for the listing of this after 2 weeks. After 2 weeks. Also, Mr. Mehdi and Mr. Porter have also taken the same care. List the cases 22 for 2000.
Item 4.
Okay, additional. Okay. Yes, Mr. Deka?
Yes, sir.
As Deka for the petition, and Mr. H.K. Das, Lion Standing Council, GHP for the response number 2 and 5. Right?
Yes.
2 to 5 or 2 to 5, pardon. 2 to 5.
2 to 5.
2 to 5. 2 dash 5. Mr. Ross, standing of this GST has submitted it. He has also received instructions in respect of the additional affidavit filed by the petitioner. He has prayed for and is granted 3 weeks' time to file a consolidated affidavit traversing the contentions made in the writ petition as well as in the additional affidavit. Please take
On
the interim order. Past shall continue till then.
Obliged.